Okay, so in the last class we discussed the fundamental rights. We talk about Article 23, which prohibit traffic in human being. We talk about bakery, what is forced labor. Then we discuss Article 24, that is employment of children below the age of 14 years. Then we come to the very famous article, that is Article 25 to 28, that is your freedom of religion. Freedom of religion. We discuss Article 25, that is to propagate and practice and profess any religion of their choice. Article 26, 27, 28 we discussed. Then we came to cultural and educational rights. Article 29, which provides for the protection of the interest of the minority. Article 30, we discussed the Kerala Education Bill case. Okay, where the minority have the right to establish any educational institution of their choice. Then we come to the very famous, the heart and the soul of the Indian Constitution, that is Article 32, in which we discuss the five type of writs, that is habeas corpus, mandamus, prohibition, certiorari, and quo warranto. We discussed, and the last was the Article 35, that was of not much importance. Now today we will be starting with the DPSP, that is Directive Principle of State Policy. So the first thing that we have to know for the Directive Principle of State Policy is that, like like the fundamental right or against which we can move to the Supreme Court if there is a violation. If there is a violation, then we can move to the Supreme Court if it is a violation of the fundamental right. But in case of the directive principle of state policy, the directive principle of state policy are not enforceable in any court of law. The directive principle of state policy, it cannot be enforced. They were made by the framer of the Indian Constitution so that any time when the legislature is making any law or the judiciary is upholding any judgment, this directive principle of state policy they should be considered. And while we were discussing the sources of the Indian Constitution, we have discussed that the directive principle of state policy is borrowed from Ireland. So we have to remember that you cannot file a petition relating to directive principle of state policy. However, you can ask the judiciary or you can request the judiciary to give the direction to the legislature to take into consideration the directive principle of state policy whenever they are making any law or whenever they are in upholding any judgment. So the directive principle of state policy are not it is not arranged systematically, because I have arranged them according to the Gandhian principle, according to the economic judgment, that you don't have to know. So we will be starting with Article 38 of the directive principle of state policy, which tells that Article 38 of the directive principle of state policy tells that the state shall strive to promote the welfare of the people by securing and protecting as effectively as it may be a social order in which justice, social, economic, and political shall inform all the institution of the national life. That means a social order will be secured by the state. That is the promotion of the welfare of the people comes under Article 38. Nothing more you have to know. Just you have to know that which article of the directive principle of state policy talks about what. Then we have Article 39, which talks about this is a very famous question of the polity, that which article of the Indian Constitution talks about equal pay for equal work. Those who are preparing for BHU, MSCT, or any of the judiciary favors, you must have seen this question many times, that which article of the Indian Constitution talks about the equal pay for equal work. So it is Article 39 of the Indian Constitution, which talks about the equal pay for equal work. This is a very important article, and it is a very famous question. Yeah, this is a very famous question of the polity question. Then you have the right to adequate means of livelihood for all the citizens. These are the discussed in directive principle of state policy. You just have to know that which directive principle of state policy talks about what. Now there is a very famous directive principle of state policy, that is 39A. Okay, 39A, that is the free legal aid, which states that the state shall secure that the operation of the legal system promote justice on a basis of equal opportunity, and shall in particular provide free legal aid The state shall provide free legal aid to those who are not able to file a petition in the Supreme Court, okay, or those who are not able to procure a lawyer for their defense. For them, it is the duty of the state to provide them a free legal aid. That is Article 39A. And it will be the duty of the inspector in charge of that police station to inform him that that to the culprit that you, if you are not able to pay the fees of the lawyer, if you are not able to pay the fees of the court, okay, you must be knowing that even there is a payment that you have to make to the court, okay, to the registrar of the court. So if you are not able to make the payment to the lawyer, or if you are not able to make the payment to the court, in that case you can use this Article 39A. But it is a very important thing that it can only be, this benefit of Article 39A, it can only be given to the one who, because of the reason of economic reason or some kind of other special ability. Matlab that you tell disability, I refer to as special ability. Especially means the disabled people they are called. Okay, they are specially abled people. So 39A is only for those who are economically weaker people or those who are specially abled people. It is only for that. That is 39A. There is a very famous case of Manoharan versus Sivarjanan case. You don't have to write the case name. It is a 2014 judgment of the Supreme Court, Manoharan versus Sivarjanan case, in which it was held that the promotion of the justice through legal aid also include waiver of the court fee in case the plaintiff is incapable of paying it. If the plaintiff is in case yeah, in case the plaintiff is incapable to pay the court fee, है ना? No, he is not only able to procure a lawyer for his defense, but for his or her defense, but he is not able to pay the court fee. There is a court fee that you have to pay to the registrar of the court. In that case, that is the Manoharan versus Sivarjanan case of 2014. It is a very latest judgment of the Supreme Court. It was held that even there will be a waiver of the court fee if the plaintiff is from the economic section or from the specially abled section. That is Article 39 and 39A. Then there is Article 40, but it comes under the Gandhian principle. So we will be discussing Article 41. This is the article which is related to the right to work, education, and to public assistance in certain cases. What is state? That the state shall, within the limit of its economic capacity and development, make effective provision for securing the right to work, to education, and to public assistance in case of unemployment, old age, sickness, disablement, and in other cases of the undeserved want. So the state, it is a duty of the state, as we discussed that the directive principle of state policy are not enforceable. So you cannot go to the Supreme Court and tell that this is my fundamental right. The state have to give me. The state have to give me employment. The state have to give me education. Although you have 21A, that is right to education for 6 to 21 years. Sorry, 6 to 14 years. Okay, I hope now you must be remembering all the articles that we have discussed. Any day I can ask anyone that what is this article, what is that article, so be ready for that. So because it is the directive principle of state policy, you cannot go to the court and tell that, ask the central government or the state government that give me education, give me work, give me public assistance, because it is a directive principle of state policy. But you can tell that when a law is made, make sure that the legislature include Article 41, which talks about the education, the employment, and the public assistance in cases of unemployment, old age, sickness, and disablement, and in other of the undeserved want. So that is Article 41. Now we have the very beautiful and the very a very prominent article, that is Article 42, that is just and human condition of work and maternity relief. You must have heard, if you are referring to the live law or the bar and bench, okay, you must have seen various cases related to maternity relief always comes into light. Various cases of the maternity relief always comes into light. So this is Article 42, which talks that there should be provision for the maternity relief and for the just and the human condition of the work. Okay, so Article 2 specifically speaks of the just and the human condition of the work and maternity relief. Now it was held by, in the case of MCD versus female worker. Okay, it was held in the MCD versus female worker 2000 case of Supreme Court. It was held. Means in this case, what happened? The validity of the executive or the administrative action in denying maternity relief was to be administered in view of Article 42. So the Supreme Court told that although this is not enforceable in law, although being a directive principle of state policy, Article 42 is not enforceable in law, but whenever the government, the executive is making any law for the employment of the people, it should take into consideration Article 42 and give maternity relief to all the pregnant women. So that is Article 42. This is the case of MCD versus Female Worker 2000 judgment treatise of the Supreme Court, AIR 2000, in which it was held that even it is not enforceable in the law, but while the executive or the administrative, and administration means you are government, which wherever you are working, that administration, they have to take into consideration Article 42. This is Article 42. Now we come to Article 43, because these are something that you just have to remember which article talk about what. If there will be any prominent or some example case, example will be there, definitely I will be telling it, but just you have to remember that which article of the directive principle of the state policy talk about what. Okay, then we come to Article 43, that is decent standard of living. Article 43. So the state shall endeavor to secure by suitable legislation or economic organization or in any other way to all worker, agricultural, industrial or otherwise work, a living wage, condition of work ensuring a decent standard of life and full enjoyment. Okay, there should be a wage, a decent wage should be given to the worker. They should be in a, they should be given a decent standard of life. There, the condition of the work means wherever they are working, they should be given a very good accommodation. There is a very famous case of Vijay Cotton Mills Limited versus State of Ajmer, that is 1955 Supreme Court case. Vijay Cotton Mill, Vijay Cotton Mill versus State of Ajmer, 1955 case of Supreme Court. What it was held? See, it has been held that the fixation of the minimum wages of the laborer by the legislature. Okay, in this case, what happened? The businessman and the industrialist, they challenge that how can the government fix the minimum wage? है ना? How can the government fix the minimum wage when we have the Article 19 Clause 1G? Anyone who can tell that what is Article 19 Clause 1G? Very good. Very good. So Article 19 Clause 1G talks about the trade and business. So they told that how can the minimum wage be fixed by the legislature? Okay, when we have Article 19 Clause 1G, the Supreme Court in the Vijay Cotton Mill Limited versus State of Ajmer 1955 case held that the fixation of the minimum wage of the laborer by the legislature is in the interest of the general public, and therefore it is not violative of the freedom of trade, which is under Article 19 Clause 1G. Okay, so so the Supreme Court told that it is very necessary that this kind of restraint should be held on Article 19 Clause 1G, that is freedom of trade, because otherwise the industrialists will, they will use it in the wrong way, Article 19 Clause 1G, and then the workers, they will not be getting the decent wage, the decent standard of living and the accommodation which is being discussed in Article 46. Now we have in between we have Article 45 and all, but we will be coming Article 47. You must be thinking that why this is up and down. This is the reason is that under directive principle of state policy, you have three things: Gandhian principle, state duty, enforceable law. So that's why these are in the same this way. You don't have to remember which is under the Gandhian principle or which is under the enforceable part. You just have to remember the article. Article 47 talks about the duty of the state to raise the level of the nutrition and the standard of living and to improve public health. This article was used in various cases in this corona pandemic. Okay. The state shall regard the raising of the level of nutrition and the standard of living of its people and the improvement of public health as among its primary duty, and in particular, the state shall endeavor to bring about prohibition of consumption except for medical purpose of intoxicating drink and of drugs which are injurious to health. So, it is the duty of the state to raise the level of the nutrition to make sure it should be the primary duty of the state to make sure that the standard of the living of the people is maintained. There is an improvement of the public health, and the state should endeavor to prohibit the consumption of the liquor. There is a case of State of Bombay versus F.N. Balsara. Now, what happened in this case? In this case, the Supreme Court held, this is a case of 1951 AIR 1951 Supreme Court. The Supreme Court state that this is a directive that the state should endeavor to bring about prohibition of consumption of intoxicating drink except for the medical purpose. It was in this case that the Supreme Court told that except for the medical purpose, the state should endeavor to prohibit. Now that is the thing, guys. See, Article 47 is a directive principle of state policy, so it cannot be enforced. You must have seen during the pandemic how there were lines of people standing before the government wine shop, before the bar shop when they were open during the pandemic. Okay, then you have the Bihar and the Gujarat state. You must be knowing that how the liquor is being banned by the Bihar and the Gujarat government, but it cannot be implemented. I am telling you very frankly, if anybody is there here from Bihar, anyone is there from Bihar, if is there anyone from Bihar or Gujarat? The Bihar government and the Gujarat government, they brought the legislation to prohibit the sale consumption of this liquor, but it has not been implemented. If you want a liquor in Bihar, you just tell any of the tempo wala and you will be getting a liquor at double of the price. For example, if the price of that liquor is 1200, you will be getting at 2000 the same liquor, whatever it is, whether it is a wine or whether it is a beer. So, being a directive principle of state policy, it is not, we are not able to implement this, and the major reason is this is a very matlab, it is a source of fund for the government, whether it is a Bihar government or whether it is a Gujarat government or whether it is a central government. The liquor is a very matlab, बहुत ही, it is a source of fund for them. Okay, so they cannot stop it. So in the state of Bombay versus F.N. Balsara, it was held by the Supreme Court that except for the medical purpose, okay, except for the medical purpose, we can use, the state can prohibit the liquor consumption. Okay, so that is your Article 47 to raise the level of the nutrition standard of living, improve public health, and to endeavor to bring about the prohibition of the consumption of the liquor except for the medical purpose and the intoxicating drinks. So this is a very good issue. You can, whenever you are free, you can do a research on this liquor issue in view of Article 47. Okay, that what is the reality of this liquor case when we have Bihar government who has banned it, Gujarat government who has banned it, but still people are getting it. I will give you the example of the trains. If you are from Jharkhand, Bihar, anyone, okay, when you ride a train in Jharkhand, you will see that either the children, you must have seen the Rice movie, okay, Rice movie where the small kid carry the drugs. In the similar manner, when you ride a train in Jharkhand which go to Bihar, you will be finding either the small children or the women in big bag, okay, they keep the liquors and they carry it to Patna, and from there it goes to Muzaffarpur and all. Or sometime even I have seen that, means in the washroom of the train, the upper part of the washroom train where the light is present in the washroom, they open it with a screwdriver and put the wine or the beer in that and send it to the Bihar. And even there, the station master, the driver of the train and the guard of the train is indulged in this. From the station master to the driver to the guard of the train is indulged in this. Just before the train enters Patna, the driver stop the train, the guard stop the train, the station master is involved, and all this wine that are in the washroom of that particular train, they are being taken out by the people and then it is sold. So this is the reality. This is the reality of Article 47 and the ban of the liquor in Bihar and Gujarat. This is the reality. So you can do a research on this. This is a very good issue to research that what is the reality of this liquor ban. And it is not possible also because of the fund of the state government that they are getting from this liquor. Then we have Article 40 of the Indian Constitution. This is the Gandhian principle, that is the organization of the village panchayat, which state that the state shall take step to organize village panchayat and endow them with such power and authority as may be necessary to enable them to function as unit of self-government. When you were in class 9, 10, if you have studied history and civics interestingly, I know most of you don't study history and civics with interest, but if you have studied history or civics interestingly, you have heard that 3-tier government at the district level, block level, district level, Jila Parishad. You must have read about it. That is the self-government. So Article 40 is the Gandhian principle. It is one of the, it was one of the vision of Gandhi ji, and tomorrow we are going to celebrate the 75th year of India's independence. Okay, so it is a coincidence. So at the organization of the village panchayat, that is the state shall take step to organize village panchayat and endow them with such power for the self government. Now this article 40, when we will be discussing the important amendment to the constitution, we will be discussing in detail. That is the 73rd amendment. The 73rd amendment talk about the introduction of the Panchayati Raj system in part 9. Now what is part 9? That we will be discussing when we will be discussing schedule. Part 9 of the Indian constitution, for example, see, part 1 was about the union and territory, part 2 citizenship, part 3 fundamental right, part 4 is fundamental duties. So part 9 of the Indian constitution talks about the 73rd amendment, which is the organization, that is the Panchayati Raj system was introduced, है ना? And just for your matlab, not so much important, but it is important. The Panchayati Raj system is the recommendation of the Balwant committee. Okay, it is a recommendation of the Balwant committee, है ना? The Balwant committee recommended the Panchayati Raj system. So you should be knowing this. See, law is same as your current affair of Clat. It is ocean. Whatever, मतलब how much you will go in deep, that is the important thing, है ना? जितना अंदर जाइएगा उतना इंफॉर्मेशन आपको मिलेगा. So 40 is village panchayat, 73rd amendment, part 9, and the Balwant Rai Mehta committee, it suggested the Panchayati Raj. Now we come to Article 43. Article 43 is the living wage for the worker, that is the promotion of the cottage industry. We have already discussed because it is a Gandhian principle. So again it's come, no need to discuss here. Now come directly to Article 46. We have discussed Article 43 already. The state shall promote with special care the educational and economic interest of the weaker sections of the people, and in particular of the scheduled caste, scheduled tribe, and shall protect them from social injustice and all form of exploitation. Okay. Article 46. Article 46 states that the state shall promote with special care the educational and economic interest of the weaker section of the people, and in particular of the scheduled caste and scheduled tribe, and shall protect them from social injustice and all form of exploitation. That is Article 46. That the for the scheduled caste, scheduled tribe, for the weaker section, the state should work, है ना? Like the reservation concept that the government brought, or the whatever the recently the EWS reservation. In all this, apart from Article 15 clause 4, they have used this directive principle of state policy 46, but they don't use this in the case of uniform civil code. A very beautiful article of the Indian constitution is coming very soon. I hope yeah, it is there only. See, okay. So Article 4, Article 14 of the Indian Article 44 is the, just a minute guys, just give me a minute. Yeah, so sorry, it was an urgent call I got. So that only I was telling that for the reservation, the government has used this Article 46, that is directive principle of state policy, but the government is not using for this. We will be discussing, this is a very controversial issue, so we will not go into the controversy, but we will discuss Article 44 in detail. Okay, and we will be also organizing debate also on this uniform civil code. Okay, so Article 46 we will be discussing. Now this is the case of state of Madras versus Champakam Doirajam. In this case, the Supreme Court, just give me a minute. Yeah, it was in the state of Madras versus Champakam Doirajan. The Supreme Court held that the fundamental right have a supremacy over the directive principle of the state policy. Very important case, guys. This is the state of Madras versus Champakam Doirajam. This is a case of 1951. 1951 judgment, Supreme Court, 1951. Supreme Court told that fundamental right has a supremacy over the directive principle of the state policy. And then you have the Indira Swane versus Union of India. This is a landmark judgment. All of you know what is Indira Swane versus Indira Swane versus Union of India judgment. Now here I am not going to tell that the Indira Swane the 50% cap. I am not discussing the 50% cap here. What we have to discuss here in Article 46, in the Indira Swane judgment versus Union of India, the Supreme Court has observed that the expression weaker section of the people, the weaker section of the people, it is related to all section of the society who are rendered weak due to various causes like poverty, natural causes, or whether they are specially able. Okay, guys. Indira Swane versus Union of India, that is a 50% cap. All of you know this. In view of Article 46, in which we are discussing the promotion of the educational and economic interests of the scheduled caste and scheduled tribe and other weaker section of the society, this weaker section जो part है, it was explained by the Supreme Court in this case. Here the Supreme Court told in Indira Swane versus Union of India, the weaker section include all the sections of the people of the society who are rendered weak due to the various causes including poverty, natural and the specially abled reason. I hope 46 and up to this is clear for everybody because it is half an hour over. Everyone, it is clear whatever we have discussed till now? Yeah. Okay. Now we come to Article 47. That we discussed already. We have discussed the F and Balsara versus State of Bombay case. Okay, because it is a Gandhian principle also. This 47, it is a Gandhian principle also, and it is a one of the part of directive principle also. So it has come 2 times. Now, Article 48. Organization of animal husbandry and agriculture. The state shall endeavor to organize agriculture and animal husbandry on modern and scientific line and shall in particular take steps for preserving and improving the breeds and prohibiting the slaughter of cows and calves and other milch and draught cattle. The recent today article, the means now you are in the here in the Google Meet on the group just before the beginning of the session. I have sent the today's important article. You will be finding the Assam new bill in which they tell that the selling and the slaughter of the cow within 5 kilometers of the temple is not permitted in the Assam. After the session, you will just when you will be checking the group of lighting team, you will be finding it. So Article 48 is the organization of animal husbandry and agriculture and the slaughter of the cows and the calves and other draught cattle. That is Article 48. Now we come to the most controversial, and recently you must have seen how this article is being means this is in news from the last 1 year. It is very much in news. Article 44. The state shall endeavor to secure for the citizen a uniform civil code throughout the territory of India. Recently, the Delhi High Court has told that now it's time that we should move to the uniform civil code. Recently, the Kerala High Court has told when they were giving the judgment of the marital rape, they told that now uniform laws should be there regarding the religion. Recently, the Bombay High Court has told the uniform laws, and recently the Supreme Court has emphasized on the uniform civil code. They have told that now we guess that the time has come to implement the uniform civil code. But we will be discussing this little bit in this debate, in this detail, because being a law student, we should always be ready for any debate or discussion. So uniform civil code का मतलब यहाँ पे what is it is that there will be no personal law for Hindu, for the Muslim, for the Sikh, for the Parsi, for the Christian. There will be a uniform law of marriage. Now we have the Hindu Marriage Act. We have the Special Marriage Act. There will be uniform divorce law, Hindu Divorce Act, Muslim Divorce Act. We have special laws for the divorce. We have special law for the succession, Hindu Succession Act. We have special act for the. We have the special laws for the adoption, Hindu adoption, and something is there. I don't remember the whole name of the act. Hindu adoption and something it is there. So we do we uniform civil code means that for the Hindu, for the Muslim, there will be a common law in view of marriage, adoption, succession, whatever it is, apart from other things. Now, why we are uniform civil code is in every matter, but why the discussion always arise on this marriage, succession, adoption? The reason is because we have Article 25 of the Indian Constitution. Anybody? What is Article 25 of the Indian Constitution? Let's see how much you are attentive in the class from the last 5 class we are already done. Article 25 of the Indian Constitution talks about what? Anyone?
Right to profess or practice any
Yeah,
religion.
yeah, very good. So, the freedom to practice, propagate, and profess religion of one own choice. Means, agar tomorrow the government implement the uniform civil code. Why I am telling tomorrow? Because it is 15th of August. Anything can happen from the Red Fort because tomorrow the Prime Minister of India will be hosting the national flag and not the president. So, so that was just a joke. Nothing else. Don't take it seriously. If tomorrow the uniform civil code is implemented in the country, there will be danga that you tell. I'm telling you, this is frankly. There is nothing means there is no need to shy or something like that. There will be tomorrow danga among all this religion. The first is Article 25. If Uniform Civil Code is implemented, they will challenge it on the basis of Article 25 that it would infringe the fundamental right to freedom of religion mentioned into Article 25, and secondly, it would be a tyranny to the minority people who are having special right given. If there will be uniform civil code, the minority will not be given that respect, or not the respect means the provisions, the special favor that they are being given now, that they are being given now. You must have remembered during the time of Indira Gandhi when the reservation was removed, the people of the scheduled caste and the scheduled tribe, they started to pour petrol on themselves and burn. Okay, that you till the Atmada, they started to pour petrol on themselves and started to burn themselves in the front of the Parliament of India. So this uniform civil code is a very controversial topic. Article 44. You must debate on this. You must research on this. Okay, this is a very good topic to debate and discuss and write article on it. Uniform civil code. So it talk the states shall endeavor to secure for the citizen a uniform civil code throughout the country. Now all even the judiciary. Now see guys, the thing is that now the Delhi High Court or the Supreme Court has even many time emphasized that now it is the time to implement the uniform civil. But I am giving you one very much. I am a very common law student. I know my solution will not be taken into consideration. But one of the way by which this uniform civil code can be brought in the country, that directly the government, whichever government it is, whether it is the BJP or the Congress, ND or the UPA, directly they should not bring Article 44 Uniform Civil Code. Try to understand my point. If you will be doing any research tomorrow, this point will help you. Or if like lighting dreams or if anywhere there is a debate organized, this point will help you. Uniform Civil Code at one go it should not be implemented. First of all, the government should bring uniform marriage law. The government should bring uniform adoption law. The government should bring uniform succession law. Once these three things are done in the next 3 years, in 2022, 2023, 2024, then in 2025 the government should bring uniform laws for the provisions for the minorities. 2025. And then in 2026 or 2027 the government can then bring the uniform civil code, because by 2026 everything will be uniform only. It will just for the sake of uniform civil code, you will be bringing a law, the Uniform Civil Code Act 2026. Before that, you will be having the Uniform Marriage Act, the Uniform Adoption Act, Uniform Succession Act. So this is one of the solutions according to me. Means whenever if I will be getting time, I will be writing a blog on this and sending you to in the on the writing dreams. Okay, because this is a very controversial matter, so I don't want to write on blog on this. But this is my personal suggestion that this can be one of the way by which the Uniform Civil Code can be implemented. That not at one go the government should bring the Uniform Civil Code Act 2021. Slowly they should be bringing the uniformity. That's this much is discussion. I guess this is matlab, more than enough for you now. Now we come to Article 45. The state shall endeavor to provide early childhood care and education for all children only until they complete the age of 6 years. Okay, we know Article 21A. The state shall provide education to children from 6 to 14 years. That is Article 21A, and this is the directive principle. Article 21A, that is right to education, and this directive principle of state policy 45 is how the state shall endeavor to provide early childhood care and education for all children until they complete the age of 6 years. Okay, keep some time for 1 hour at least to watch the debate that happens on the Rajya Sabha big picture. Okay, it happens every day on the whatever is the latest law. Okay, so try to see that debate. It is very beautiful thing. See, only clat every time. Clat is not the everything. Clat is the thing for the NLU, but every time, if now this is the month of August. Okay, now you don't have to prepare for 10 hours for clat. You have many matlab, you have a lot of time left apart from clat preparation. So you should involve in all this kind of thing. You should watch this kind of debate. It is a very good debate. Every day happens on the big picture on the Rajya Sabha. You can watch it on the YouTube also. Now, Article 48 we have done. Now we come to Article 49. Article 49 tells that it shall be the obligation of the state to protect every monument or place or object of artistic or historic interest to be of national importance from exploitation, disfigurement, destruction, removal, disposal or export as the case may be. You must have seen the controversy regarding the central vista, है ना? ताजमहल काला पड़ रहा है. You must have seen the Taj Mahal. Those who have seen the Taj Mahal recently in the last 1 or 2 years, they must have seen that what Taj Mahal was when it was made and what it is today. So it is a duty of the state, but it is being a directive principle. It cannot be enforced, and so the government is just chill. So it shall be the obligation of the state to protect every monument or place or object of artistic or historic interest to be of national importance from spoliation, disfigurement, destruction, removal. Article 49 हो गया. Now Article 50, separation of judiciary from the executive. So although like the US Constitution, there is not, it is directly the separation is not absolute in our Indian Constitution. Remember this thing, okay? This thing will help you in future. Like the US Constitution, our Indian Constitution don't talk about the absolute rigidity of the separation of the power, but it talk that there should be a division of power and they should be functioning independently, so that there is, according to the framers, this was the in the interest of the citizen and the state. So they separated the judiciary, executive, and the legislative. You must have seen there are various cases on this. है ना? There is a case of MC Mehta versus Union of India. It is a very famous case. Okay, MC Mehta versus Union of India. So absolute separation is not talked about in the Indian Constitution. We have just a separation of the power. Now we come to Article 51, that is promotion of international peace and security. The state shall endeavor to promote international peace and security, है ना, maintain just and honorable relation between nation, foster respect for international law and treaty, encourage settlement of international dispute by arbitration. That is Article 51. That is the promotion of international peace and security. Now one article is Article 48A, that is the state shall endeavor to protect and improve the environment and to safeguard the forest and the wildlife of the country. There are various laws you can see. The best is the Environment Protection Act 1986. है ना? Environment Protection Act 1986 is the most pertinent thing related to Article 48A, that the state shall endeavor to protect and improve the environment and to safeguard the forest and the wildlife of the country. Okay, then you must have seen that the conversion of the diesel motor vehicle plying in Delhi to CNG, है ना? So it was challenged in the Supreme Court, but the Supreme Court upheld this. Once again, I am repeating, the conversion of the diesel motor vehicle plying in Delhi to CNG. It was, I guess, in 2012 or 13 time. The Supreme Court upheld this thing in view of Article 48A, that this is the directive principle of state policy. We must work in this regard, and all the diesel motor vehicles should be immediately stopped. So these are the directive principle of the state policy from Article 36 to Article 51. Okay, we will stop till here only, because from tomorrow we will be starting the part, uh, the next part of the Indian Constitution, that is the part 5, the Union, in which we will be discussing the executive. So if I will start the executive now, it will take 45 minutes. So we will stop today here only. Thank you, and